Cross-examination is one of the most powerful and risky parts of a trial. It's where you put pressure on the other side's witnesses, test the strength of their story, and redirect the narrative in your client's favor. But this is also where language becomes a legal weapon. Every word matters. Every question you ask must have a purpose. And this lesson, we will learn how to challenge credibility without sounding aggressive, use vocabulary like impeach, inconsistency, leading question, control tone, and build pressure through emphasis, logic, and timing. And most importantly, we will see how questions can win or lose a case. By the end of this class, you'll be able to simulate courtroom questioning in English with confidence and clarity and sound like a legal professional, not a language learner. Let's warm up by thinking critically what actually makes a good cross examination. It's not just about asking questions, it's about controlling the courtroom through subtle strategy and precise language. Think about, should you let the witness talk freely or keep them on a tight leash? Do you challenge their credibility directly or set traps with careful logic? When should you raise your tone or lower it to increase pressure? Let's complete a few sentences to get into the courtroom mindset. A good cross examination should expose inconsistencies without sounding hostile. When cross examining a hostile witness, a lawyer must stay composed and use tight, close ended questions. If the witness contradicts themselves, then the lawyer can use their prior testimony to undermine their credibility. These are the dynamics we'll explore today through vocabulary, grammar, phrases, and real simulations. A leading question is one of the most important tools in cross examination. Unlike open ended questions used in direct examination, a leading question suggests the answer the lawyer wants. For example, isn't it true that you were at this scene that night? This type of question limits the witness's ability to explain or deviate. It keeps control in the hands of the lawyer, which is exactly the goal in cross examination. Typical forms include, would you agree that? So, you didn't see anything clearly, correct? You told the police you left at 10 p.m., didn't you? Leading questions are usually allowed during cross examination, but may be objected to if used during direct examination. To impeach a witness in legal English doesn't mean to remove them from office. It means to attack their credibility. This is a central goal of cross examination to show that the witness is unreliable, biased, inconsistent, or dishonest. For example, the defense sought to impeach the witness by highlighting inconsistencies in her prior statements. Common ways to impeach a witness include pointing out contradictions in their testimony, referencing prior inconsistent statements, or demonstrating bias or motive, challenging their ability to perceive or recall the facts. Phrases you will often hear in court. We intend to impeach this witness using her earlier deposition. Your Honor, this line of questioning goes to impeachment. Impeachment material was disclosed during discovery. Knowing when and how to impeach a witness using professional language is a high-level courtroom skill. In cross examination, one of the most effective ways to weaken a witness's testimony is to expose an inconsistency. An inconsistency is when a person's statements don't align, either with their own previous statements, with other evidence, or even within the same testimony. For example, there was a clear inconsistency between the witness's statement in court and her earlier affidavit. Why are inconsistencies so important? Because they allow a lawyer to suggest the witness is unreliable or dishonest. can introduce reasonable doubt and undermine the overall credibility of the other side's case. You'll hear common legal collocations such as pointing out inconsistencies in testimony, a material inconsistency between the police report and the witness's account. Cross examination revealed several inconsistencies. Mastering how to spot, describe, and challenge inconsistencies is essential for any litigator and for your courtroom English. To elicit testimony means to draw out evidence from a witness, often strategically. This isn't just about asking questions, it's about framing your questions in a way that reveals useful, often unexpected information. For example, the attorney successfully elicited testimony that contradicted the earlier timeline. During cross examination, skilled lawyers use tightly worded questions to elicit contradiction, hidden motivations, details the witness might not volunteer. It's the opposite of passive listening, it's active legal strategy. Common phrases you'll hear are counsel was able to elicit damaging testimony under pressure. The testimony elicited on cross raised serious credibility concerns. The judge reminded counsel not to elicit speculative responses. In professional courtroom English, this verb elevates your language, and it's much stronger than simply saying ask. In any trial, credibility is everything. A witness may speak clearly and confidently, but if the jury or judge doesn't believe them, their testimony is worthless. Credibility refers to a person's perceived honesty, accuracy, and reliability as a source of information. For example, the witness's credibility was seriously damaged after the contradiction was revealed. In cross examination, your goal is often to undermine the credibility of the opposing party's witnesses. This can be done by pointing out inconsistencies, showing bias or conflict of interest, exposing gaps in memory, or confusion about facts. You'll hear key legal phrases like, the issue before the court is the witness's credibility. Counsel sought to cast doubt on the witness's credibility. Credibility was a central factor in the jury's decision. When lawyers speak about trial outcomes, they often say it came down to credibility. Hearsay is one of the most important and often misunderstood terms in trial law. It refers to a situation where a lawyer tries to introduce a statement that was made outside of court to prove something inside the trial. For example, the objection was sustained because the lawyer was relying on hearsay. In most legal systems, hearsay is inadmissible unless it falls under a specific exception, such as dying declarations, business records, or spontaneous utterances. Why? Because the original speaker is not in court to be cross examined, so their reliability cannot be tested. Typical courtroom phrases are objection, hearsay. That's an out of court statement being offered for the truth of the matter asserted. The judge ruled the statement inadmissible as hearsay. Understanding and applying hearsay rules, especially in cross examination, is essential to courtroom fluency. In courtroom English, to distort the record means to intentionally or carelessly misrepresent what actually happened, especially during testimony or legal argument. For example, the opposing counsel accused the witness of distorting the record to favor their version of events. This term is often used when a witness selectively recalls events, a lawyer quotes testimony out of context, a party misuses prior evidence to support an unfair narrative. You'll hear common legal phrases such as, counsel is attempting to distort the record in their summary, or that characterization is a distortion of the factual record, or We request the court to correct the record to prevent distortion. This phrase is formal, precise, and suitable for both spoken advocacy and written legal arguments, particularly in appellate or high-level litigation contexts. To mischaracterize the evidence means to present facts in a way that alters their original meaning, whether intentionally or not. This term is commonly used when a lawyer misstates what a witness actually said, interprets a document in a misleading way, summarizes facts selectively to support an unfair conclusion. You'll hear examples such as counsel objected, arguing that opposing counsel was mischaracterizing the evidence. This is a powerful objection in court. It signals to the judge that the opposing party is not being faithful to the record. Typical courtroom phrases are objection, mischaracterization of the evidence, or that statement mischaracterizes what the witness actually said, or we urge the court not to rely on mischaracterized summary of the facts. This is high-level, neutral courtroom language often heard in trial advocacy and appellate litigation. To misstate material facts means to present important facts of the case in a way that is inaccurate, incomplete, or misleading. This is considered a serious issue, especially when it affects how the judge or jury interprets the evidence. For example, the judge warned counsel not to misstate material facts during closing arguments. Let's break it down. Misstate is to say something inaccurately. Material facts are facts that could affect the outcome of the case. This term often arises during objections in cross-examination, in motions accusing the other side of presenting facts improperly, or in judicial opinions analyzing fairness or error. Professional phrases include counsel's argument misstates material facts presented at trial, or there is no evidence supporting that assertion. It is a misstatement of material facts, or the court cannot rely on a factual summary that misstates the record. This phrase is preferred in high-level litigation because of its neutrality, formality, and precision. Instead of the casual courtroom phrase, no further questions, more formal and technical alternative is we conclude our examination, or that concludes our cross-examination, Your Honor. To conclude the examination is to formally end your questioning of a witness, whether in direct, cross, or redirect. Example: counsel concluded the examination after establishing the timeline of events. This phrase is often used in formal court transcripts, during simulated moot court or arbitration, or by lawyers who simply wish to sound measured and professional. Other precise variations can include we have nothing further at this time, or we conclude the cross-examination, reserving the right to recall the witness, and this concludes the examination in chief. Knowing how to end strongly and professionally is just as important as asking powerful questions. Let's dive into a high-level structure that trial lawyers use all the time: rhetorical questions. A rhetorical question is not designed to get information. Instead, it's a strategic tool used to make a point sound obvious, or expose contradictions in a witness's story, or pressure the witness without sounding openly confrontational. You can also frame your narrative for the judge or jury. Here's the key: you already know the answer. The question is really for everyone else in the room. Let's take a look at a few typical courtroom forms. Isn't it true that you left the building without reporting the incident? Or you expect the court to believe this was just a mistake? Or why would someone delete all their messages if they had nothing to hide? These sound like questions, but they function as strategic assertions. The lawyer is taking control of the story. Now, let's try an example from a simulated cross. The lawyer says, "You claim the system crashed, but isn't it true that you manually overrode the security settings?" Or the lawyer could say, "Do you really expect this jury to believe that you didn't understand the terms of the agreement after signing 5 similar contracts?" These types of questions allow you to argue without arguing. You embed the accusation into the structure of the question. In professional legal English, mastering rhetorical questions is a must for persuasive courtroom speech. Let's move on to emphatic structures, one of the most effective tools for adding weight, pressure, or focus during cross examination. You don't need to shout in court to be powerful. Instead, you shift the structure of your sentence to highlight what matters. Here's how lawyers do it: cleft sentences for emphasis, used to highlight who or what is truly responsible. "It was you who had access to the restricted folder, wasn't it? It was after the audit that you changed your story, correct?" This structure shifts the tone. It sounds calm, but laser focused. Do, does, did for emphasis. Add do or did to a verb to intensify the statement. "I do find it strange that you didn't mention this earlier. You did attend the meeting on April 3rd, correct?" It emphasizes certainty without raising your voice. Or fronting phrases. Use formal phrases to frame your accusation professionally. "What I find troubling is the timeline you've provided." Or, "What the court needs to understand is that the contract was never signed." You sound measured, precise, but still forceful. And why should we use emphatic structures? Because they help you. They help you control the courtroom tone. They help you emphasize what matters most and helps put the witness under pressure without becoming aggressive. In cross examinations, words like do, did, what I find, and it was you who give you a sharp edge without open hostility. Let's finish with one of the sharpest tools in cross examination: conditional logic. Conditionals allow lawyers to highlight cause and effect, test hypothetical scenarios, or trap a witness in their own contradictions, all using grammar. And there are 3 forms particularly useful in the courtroom: real conditionals, if plus present, comma, will plus base verb. Use these for direct consequences. "If you didn't see the accident, how can you testify that it was the defendant's fault?" Or, "If you were so concerned, why didn't you report it immediately?" 2 unreal conditionals: if plus past, would plus base verb. Use these for hypothetical scenarios that didn't happen. "If you had checked the system, would this data breach have occurred?" Or, "If the defendant truly intended to return the item, would he have hidden it under his coat?" These are useful for showing what should have happened but didn't. And then there are mixed conditionals and inversions. Use these for formal, high level cross examination. Had you followed protocol, this issue wouldn't have arisen. Were your story consistent, we wouldn't be having this discussion. These forms are often heard in judicial opinions, appellate arguments, and elite trial advocacy. Why use conditional logic? Because it lets you reveal contradictions without sounding hostile, lets you pressure the witness into either agreeing or exposing inconsistencies, and it also makes the jury or judge think that doesn't add up. In short, conditionals are your logical scalpel in the courtroom. Let's begin with the phrase that's precise, professional, and powerful in court: inconsistent with the record. Lawyers use this phrase to point out what a witness is saying does not match the official documentation, such as depositions, filings, transcripts, or evidence entered into the record. For example, that statement is inconsistent with the record provided during discovery. This is a subtle but sharp way to challenge a witness's credibility or undermine opposing counsel's argument, and also alert the court that something doesn't match the facts. Some common professional uses are: the timeline provided is inconsistent with the record. Counsel's summary is factually inconsistent with the court record, and her testimony contradicts her own affidavit and is inconsistent with the record. It's formal, neutral, and persuasive, ideal for advanced legal writing and oral argument. Our next legal phrase is a common and powerful objection: beyond the scope. This is used when an attorney believes the opposing side is asking questions outside the permitted range, usually during cross examination or redirect. For example, in most courtroom procedures, cross examination must stay within the scope of direct. Redirect must stay within the scope of cross. So if a lawyer tries to introduce new topics, you can object. Objection, Your Honor, that's beyond the scope. This protects against surprise testimony, ambush tactics, expanding the witness's testimony unfairly. Professional examples include: this line of questioning is beyond the scope of prior testimony, or the witness was not examined on this matter during direct. It's beyond the scope. Your Honor, we object. Counsel is improperly broadening the scope of this examination. It's a precise way to set boundaries and keep the other side from overreaching. Next up is a phrase that's essential for controlling the flow of testimony: lack of foundation. In court, you can't just jump into a question or introduce evidence without laying the groundwork. The judge needs to see that the witness is qualified to speak on the matter, and that the context has been set. When that hasn't been done, the correct objection is: objection, Your Honor, lack of foundation. For example, the witness has not been shown to have knowledge of this document. This objection is used when a lawyer tries to introduce a document without identifying its source or relevance, or a question that assumes facts not yet established in testimony, or a witness lacks personal knowledge of the topic. You will hear professional variations such as: there is no foundation for the witness to testify on that issue, or objection, lack of foundation and personal knowledge. Or before counsel proceeds, they must lay a proper foundation for the exhibit. It's a powerful way to stop improper questioning and protect the record. Our final legal phrase is one of the most important techniques in cross-examination: to impeach the witness. In legal English, to impeach does not mean to remove from office. In the courtroom, it means to challenge a witness's credibility, to show that their testimony is unreliable, inconsistent, or biased. For example, the attorney introduced prior testimony to impeach the witness. You can impeach a witness by quoting a prior inconsistent statement or showing contradictions between earlier and current testimony, or proving bias, motive, or interest in the outcome. Also, demonstrating lack of memory or accuracy. Key courtroom uses are: we intend to impeach the witness with their prior deposition, or objection overruled. Counsel may proceed with impeachment. Impeachment goes to the heart of the witness's credibility. This is advanced legal language commonly used in trial advocacy, evidence law, cross-examination preparation, judicial rulings on admissibility. Every skilled litigator must know when and how to impeach. It's a core strategy in discrediting testimony without directly accusing someone of lying. In a recent financial misconduct case, the cross-examination centered on a key witness, a senior financial officer who had approved several high-value transfers now under scrutiny. The examining counsel approached methodically, not with accusation, but with carefully constructed language. First came the emphatic framing. It was the witness who held the final sign off authority over all outgoing payments. That detail was not shouted, it was emphasized through sentence structure. Next, the attorney used rhetorical questions to shape the court's perception. If those payments were reviewed properly, why were they sent to a personal account? If the procedures were followed, why were these transactions flagged only after the audit? These questions weren't designed to elicit answers. They were meant to make the inconsistencies unmistakable and to force the fact finder to think critically. Then came the use of conditional logic. Had even one transaction been escalated for review, the entire financial irregularity might have been avoided. Had the approval checklist been properly followed, no red flags would exist today. Strategically, the cross examination was supported by precise legal objections. Testimony that contradicted prior statements was labeled inconsistent with the record. Assertions outside prior questioning were challenged as beyond the scope. Unsupported claims were blocked due to lack of foundation. Finally, the attorney moved to impeach the witness, not through accusation, but by introducing prior signed statements that directly contradicted today's testimony. The result was a textbook example of how to control a courtroom, not with volume, but with precision. Through vocabulary, grammar, and professional phrasing, the lawyer guided the courtroom from confusion to clarity and from uncertainty to doubt. Let's review everything we covered in this high-level courtroom communication lesson. You began by expanding your courtroom vocabulary, learning precise terms used to describe the legal process, from admissibility and deposition to procedural error and grounds for appeal. We then moved into grammar tools used in real-life cross-examination. You practiced rhetorical questions, not to get answers, but to control how the judge or jury interprets the testimony. You used emphatic structures to draw focus. Without aggression, it was you who, or what I find troubling is. You mastered conditional logic to highlight what should have happened. Had the checklist been followed? If you had nothing to hide. And next, you learned 4 technical legal phrases that help you navigate courtroom dynamics professionally. Inconsistent with the record to highlight contradictions. Beyond the scope to challenge improper questioning. And lack of foundation to block unsupported testimony. Also, impeach the witness to formally challenge credibility. Finally, you brought it all together in a narrative story that modeled how to use vocabulary, grammar, and phrasing to guide courtroom thinking, calmly and persuasively. This kind of advanced legal English is about more than just language. It's about strategy, tone, and clarity under pressure. You're now ready to participate in courtroom simulations, write trial memos, or engage in professional litigation discussions using real legal English.